Welcome to today's program, Legal Ethics, Trump, Gawker, and the Legal Ethics of Alternative Litigation Finance. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. The topic of today's program are the legal ethics issues that arise when someone other than the plaintiff is funding a lawsuit, which often goes by the name Alternative Litigation Finance, or ALF. We're going to discuss the legal ethics issues in the context of the two most famous ALF lawsuits that have been prosecuted to date. E. Jean Carroll's lawsuit against former President Donald Trump, alleging that he sexually assaulted and defamed her, and Terry Bollea, aka Hulk Hogan's lawsuit against the gossip website Gawker, alleging that the site invaded his privacy when it published a sex tape in which Hogan appeared. In case you are not familiar with either of these cases or don't recall the facts of the Gawker case, which happened a few years ago, I'll remind you briefly of them now. In early 2023, Trump was found liable for sexual assault and defamation in order to pay a total of $5 million in damages to Ms. Carroll. That lawsuit was funded by Silicon Valley billionaire Reid Hoffman, who was a co-founder of LinkedIn and also a founding board member of PayPal. Back in 2016, Gawker was found liable in order to pay a staggering $140 million to Hulk Hogan. That lawsuit was funded by a different Silicon Valley billionaire, Peter Thiel, who coincidentally also made his initial fortune as a founder of PayPal. In fact, both Mr. Thiel and Mr. Hoffman are part of the so-called PayPal Mafia, a network of well-connected tech executives and investors who got their start at the payments company in the late 1990s. The motives that each of Messrs. Hoffman and Thiel had for funding these lawsuits are interesting, and we will get to them in due course. For now, it's enough to observe that the two highest-profile ALF cases to date were both funded by Silicon Valley billionaires who chose to do so not as investments, as most people who provide ALF funding these days do, but for personal reasons, and also that in each case, the plaintiff ended up prevailing and winning significant judgments. The Trump verdict and jury award are still pending on appeal, but the Gawker case ultimately was settled, with Gawker agreeing to pay $30 million to Hogan. As I just alluded to, the reasons Messrs. Hoffman and Thiel had for funding these lawsuits were personal to them, and so in that case, somewhat unique versus the standard motive in ALF cases, which is that the funder is providing the funds as an investment that he or she hopes will return more in terms of a settlement or judgment than the funder had to contribute in litigation costs. Indeed, an entire industry has sprung up in recent years in which hedge funds, family offices, and other high net worth investors have been pouring money into ALF in the hopes of generating outsized returns. At a high level, you can think of ALF as a lottery ticket. In many and perhaps most cases, it won't pay off, but in the cases where it does, the payoff can be massive, and that is why these investors are chasing when they choose to fund these cases. Now, some ALF funding comes from entities that aren't in it for the profits, but rather they are looking to further some cause that is important to them. You have organizations that fund environmental or anti-discrimination cases, for example. Often these and other organizations will justify ALF funding on the grounds that it increases access to justice for people who otherwise would not be able to afford to litigate their claims, similar to the role that contingent fee arrangements play in some cases, and that's certainly true in some cases. On the other hand, ALF opponents argue that it simply encourages more and more frivolous litigation, again similar to the arguments you could make about contingent fee arrangements. There certainly is and can be a spirited and lively debate about the merits of ALF. Is it a good thing or a bad thing? But I'm going to sidestep that debate today and just focus on some of the legal ethics issues that are raised in ALF cases. I leave it to you to decide for yourself whether ALF is a good or bad, but one thing I think is certain based on the phenomenal growth it has experienced over the last 5 to 10 years, ALF is definitely here to stay. Before we get started, I need to offer a further disclaimer. The topic of legal ethics issues raised by alternative litigation finance is a massive one, and I don't have the time or inclination to try to cover all of it in a 1-hour program. What I'm going to do is explain what ALF is and talk about some of the legal ethics issues that it raises in the context of discussing the facts of the Trump and Gawker cases. Those issues fall into 4 main areas of concern for practicing lawyers. First, illegality. Second, confidentiality. Third, conflicts of interest. And fourth, independent advice. You might say that my goal today is to give you just enough information about alternative litigation finance to be dangerous, by which I mean enough information to help you spot the potential legal ethics issues if a client ever asks you to help him or her start down this path, and to use what you learn here as a jumping off point from which you can examine those issues more thoroughly before proceeding. Two major reasons for this are that the law and the legal ethics rules in this area are still evolving, and they vary a lot from state to state. What's more, most of the issues we'll raise don't have clear answers. Even according to the ABA, which issued an informational report on alternative litigation finance in 2011 that raised many more questions than it answered. You'll need to wrestle with these issues a bit in light of the facts of your case before figuring out what you think the best course of action is based on your state's law and ethics rules. So let's begin, as they say, at the beginning with some definitions. According to the ABA, alternative litigation finance, or ALF, refers to the funding of litigation activities by entities other than the parties themselves, their counsel, or other entities with a pre-existing contractual relationship with one of the parties, such as an indemnitor or a liability insurer. These transactions are generally between a party to litigation and a funding entity and involve an assignment of an interest in the proceeds from a cause of action. These activities have become increasingly prominent in recent years, leading to significant attention in the legal and popular press, scrutiny by state bar ethics committees, and scholarly commentary. At least some forms of alternative litigation finance are permitted in many U.S. jurisdictions as well, but many lawyers are unfamiliar with the ethical issues presented by these transactions. The American Bar Association Commission on Ethics 2020 therefore formed a working group on alternative litigation finance to study the impact of these emerging transactional structures on the lawyer-client relationship and the professional responsibilities of lawyers. Let me start by walking you through the facts of Hulk Hogan's case against Gawker. As I mentioned, the case arose from a now infamous sex tape that featured the former professional wrestler Hulk Hogan. Hogan sued Gawker Media, the publisher of the website Gawker.com, that had published the sex tape, and that lawsuit resulted in a staggering $140 million jury verdict in favor of Hogan and against Gawker. That judgment subsequently forced both Gawker and its CEO Nick Denton into bankruptcy, before the case ultimately was settled by the parties for $30 million. Hogan's lawsuit was funded by Peter Thiel, who chose to do so because Thiel had been out to get Gawker since one of its websites outed him and some of his friends as gay back in 2007. So far from providing ALF funding as an investment, Thiel funded Hogan's lawsuit out of spite and in an effort to shut Gawker down. This is a pretty unique situation, although, as we will see with Reid Hoffman's decision to fund the lawsuit against Trump, not entirely unusual. So, how did a former professional wrestler end up winning a $140 million jury verdict against Gawker over a sex tape? Let's start with Hulk Hogan's version of what happened. As you will see, the facts of this case don't always add up, but suffice it to say that Hogan's version of events ultimately proved credible enough to convince a Florida jury, and as I mentioned, the case was settled before the final appeals could be heard, so this is the best version of the facts that we have. According to Hogan, he slept with Heather Clem, the other participant in the sex tape, with her husband Bubba's consent. Apparently they had an open marriage, and only after he had resisted her relentless come-ons for several years. So, one day in 2006, Hulk stopped by Heather's house just to say hello, and in a moment of weakness brought on by Hogan's impending divorce from his wife Linda, he succumbed to Heather's charms. The sex itself included fellatio performed by Heather on Hogan, plus sexual intercourse. Importantly for his lawsuit, and according to Hogan, he was videotaped having sex with Heather without his knowledge or consent. But this is the first part of Hogan's story that seems suspect. For starters, after Hogan first filed his lawsuit, naming not only Gawker, but also Bubba and Heather as defendants, Bubba appeared on the Howard Stern show and steadfastly maintained that Hogan knew that he was being filmed and consented to it. In the tape itself, Bubba can be heard at the start saying to Heather and Hogan that they can do their thing and that he will be in his office. Furthermore, at various times on the tape, Hogan seems to stand aside so that the camera can see Heather lying on the bed. It seems like Hogan knew he was being filmed, or at the very least, given that Bubba was home at the time, he wasn't all that concerned about his privacy or his reputation when he decided to have sex with Heather anyway. In the first of many odd twists, just days after Bubba appeared on Howard Stern to talk about the Hogan sex tape, and shortly after he was named as a defendant in Hogan's lawsuit, he completely changed his tune, now claiming that he was convinced that Hogan had been unaware of the camera. In the first of many obvious quid pro quos in this bizarre case, Hogan promptly settled with Bubba for a token payment of $5,000, but more importantly, an assignment of the copyright in the sex tape from Bubba to Hogan. Of course, Hogan wanted ownership of the copyright in the sex tape, so that he could sue Gawker for copyright infringement, which he promptly did. Hogan ended up dismissing the copyright infringement case after losing his effort to obtain a preliminary injunction, requiring Gawker to take down the excerpt of the tape it had posted on its website and the associated article commenting on it by then Gawker editor A.J. Delirio. After suffering this setback in federal court, Hogan commenced his lawsuit against Gawker in Florida state court, and that is ultimately where he succeeded in winning the $140 million judgment. In case you were curious, Hogan also settled his claims against Heather for a mere peppercorn, but only after his act of naming her as a defendant helped him defeat Gawker's attempt to remove the state court lawsuit to federal court on diversity grounds, because Heather, like Hogan, was a Florida resident. Being able to keep this lawsuit in state court in Tampa was probably a key factor in obtaining the $140 million jury verdict, so this legal maneuver certainly paid off big time for Hogan. As I mentioned, Hogan responded to the publication of the tape by filing a lawsuit in federal court in Tampa seeking a preliminary injunction, ordering Gawker to remove the tape and the commentary. Hogan actually tried this twice, and each time, U.S. District Judge James D. Whittemore denied the motion. In the first case, holding that Hogan's requested injunction would be an unconstitutional prior restraint on Gawker's freedom of speech and the press on matters of public concern, and in the second case, that Hogan was unlikely to prevail on the merits of his claim for copyright infringement because the validity of his copyright was in question, and also because Gawker had a strong fair use defense. Interestingly, Judge Whittemore held in the first case that Hogan's own public discussion of issues related to his marriage, sex life, and the sex tape itself all demonstrate that the video is a subject of general interest and concern to the community. While this is a slightly different issue than the one Gawker argued in the state court case, namely that Hogan could not claim invasion of privacy or publication of private facts based on Gawker's publication of the sex tape, when Hogan himself had spoken openly about his sex life, it is telling that a federal judge specifically ruled against Hogan on this issue before a Tampa jury later awarded him $140 million to compensate him for damages to his reputation. Of course, denial of a preliminary injunction in part based on this finding didn't mean that Hogan was collaterally stopped from raising this issue again in the trial court, but it certainly is interesting. And it also was significant because this setback is one of the reasons that Peter Thiel got involved in the case. So, by the fall of 2012, Gawker had succeeded in blocking Hogan's claims in federal court, and that case was before a judge who clearly was not inclined to find in Hogan's favor. Enter Silicon Valley billionaire Peter Thiel, who dropped a cool $10 million into Hogan's litigation war chest. So who is Peter Thiel? Chances are you've probably never heard of him, at least until he became an early and vocal supporter of Donald Trump's presidential campaign, and then became the first openly gay person to speak at the Republican National Convention. As I mentioned, Peter Thiel earned his billions by founding PayPal, which invented internet payments, and being the first outside investor in Facebook, which invented social networking. It's an amazing coincidence that Thiel and Reid Hoffman were friends and colleagues who helped start PayPal together, and then years later, Hoffman goes on to fund a lawsuit against Donald Trump, who is one of Peter Thiel's close friends. It's a very small and a very strange world sometimes. So why did Peter Thiel want to get Gawker so much that he was willing to spend $10 million to fund Hogan's dubious lawsuit? He didn't do it as an investment, which distinguishes Thiel from most other people who provide alternative litigation finance, which is an important difference that we'll discuss shortly when we talk about the potential issues raised by Thiel's involvement in the Gawker case. Thiel did it because in 2007, Gawker's Valleywag blog published the headline, "Peter Thiel is totally gay, people," which, although it did not necessarily out Thiel, who was living openly but maybe not overtly gay by that time, Gawker's headline and subsequent posts about some of Thiel's friends ruined their lives for no reason. That led Thiel to mount a clandestine war against Gawker, which he prosecuted by hiring a team of lawyers to find and help victims of Gawker's coverage to file lawsuits against Gawker. Here's Thiel explaining why he did it in a New York Times interview after his role in the Hogan case was revealed. Quote, "It's less about revenge and more about specific deterrence. I saw Gawker pioneer a unique and incredibly damaging way of getting attention by bullying people even when there was no connection with the public interest. I can defend myself. Most of the people they attack are not people in my category. They usually attack less prominent, far less wealthy people that simply can't defend themselves. Even someone like Terry Bollea, who is a millionaire and famous and a successful person, didn't quite have the resources to do this alone." End quote. So that was Hulk Hogan versus Gawker. The facts of the sexual assault and defamation case E. Jean Carroll brought against Donald Trump are more straightforward. Ms. Carroll first disclosed her allegation that Trump raped her in a June 2019 New York Magazine article. She described a scene where Trump attacks her in a dressing room in the department store Bergdorf Goodman. While Ms. Carroll said the assault happened in the mid-1990s, she wasn't able to file a claim until 2022 after the passage of the Adult Survivors Act, which allows adult sexual assault victims to file suit regardless of how long ago the incident occurred. Trump has repeatedly denied the allegations and at one point said Ms. Carroll was not my type. The 2-week trial against Trump concluded in May 2023 after a jury in New York federal court awarded Ms. Carroll $2 million in damages for sexual abuse and roughly $3 million for defamation based on the former president's social media posts denying Ms. Carroll's allegations. Trump has filed a notice of appeal of the jury's verdict. Mr. Hoffman's support for Ms. Carroll's lawsuit, which was first disclosed in a letter to Judge Louis A. Kaplan, who was hearing the case on the eve of trial by Mr. Trump's lawyers, sparked a sharp dispute in the case. Mr. Trump's lawyers accused Ms. Carroll of concealing Mr. Hoffman's role, which they said they had only just learned from her lawyers. They said the disclosure raised significant questions about Ms. Carroll's credibility and whether her allegations against Mr. Trump were, as he has claimed, a hoax brought to advance a political agenda. Mr. Trump's defense team also pointed out an October deposition in which Ms. Carroll testified no one else was paying her legal fees. Mr. Trump's lawyers asked Judge Kaplan for a 1-month postponement so they could investigate the funding issue. Judge Kaplan denied the request for delay in the trial, but he did allow Mr. Trump's lawyers the opportunity to conduct a narrow inquiry into the funding issue and to ask Ms. Carroll about it on the witness stand to the extent it was relevant to the issue of her credibility. For their part, Ms. Carroll's lawyers had argued that the financial support was irrelevant to Ms. Carroll's legal claims and that she had nothing to do with obtaining the outside funding and no dealings with anyone associated with the nonprofit that provided the funding. They noted that it was not until September 2020, almost a year after Ms. Carroll filed the first of what became 2 lawsuits against Mr. Trump, that their firm obtained the funding to help pay certain costs and fees. They said Mr. Trump's latest effort to delay the trial, earlier this week he had asked if it could be delayed because of a deluge of pretrial publicity concerning his recent criminal indictment in New York, was his latest transparent effort to keep a jury from deciding Carroll's claims. Unlike Peter Thiel's funding for Hulk Hogan, which came directly from Mr. Thiel, Reid Hoffman's support for Ms. Carroll's lawsuit against Mr. Trump was provided through a third-party foundation, which in turn had received contributions from Mr. Hoffman. Ms. Carroll's lawsuit was funded by American Future Republic, a nonprofit group primarily backed by Mr. Hoffman. Dimitri Melhorn, one of Hoffman's philanthropic advisors, said they provide third-party funding to legal efforts to protect our citizens from violent threats, and in those cases the clients generally do not know our identity. Mr. Melhorn said in Ms. Carroll's case, the grant was made before Carroll filed suit, and they had no prior knowledge that our funding would have to go support her in particular. Mr. Melhorn also said, the movement of people who are funding initiatives like this is quite large. We are prominent in it, but we are not it, referring to the pushback Mr. Hoffman received for his funding of Ms. Carroll. That pushback mirrored that of another Democratic megadonor, George Soros, who became a talking point for many on the right. Once the public learned of Mr. Hoffman's role in the Trump case, Mr. Hoffman posted on LinkedIn to defend his involvement in the case, describing his commitment to protecting the rule of law from the threat of Trump's scorched earth legal methods, also noting that Trump's hostility to women has been a theme of his ideology for his entire adult life. Hoffman also pushed back against Trump's lawyers' descriptions of the funding as being hidden and said he'd never taken any steps to hide the financial support he provided to the lawsuit. While Hoffman is known for his work founding LinkedIn, he's also a big Democratic donor, funding a number of Democratic causes, candidates, and legal battles, including civil lawsuits filed by the victims of the Unite the Right rally in Charlottesville, Virginia, according to a post on LinkedIn. Let's now turn to discuss the legal ethics issues that Mr. Thiel's arrangement with Hulk Hogan in the Gawker case and the arrangement between Mr. Hoffman and E. Jean Carroll in the Trump case likely created for the lawyers in those cases. I should say that I'm not privy to any non-public information about either of these cases, and to date, no claims have been made that Hulk Hogan's or E. Jean Carroll's lawyers violated any laws or legal ethics rules in connection with their representation of their clients in those cases, nor have any claims yet been made that Peter Thiel or Reid Hoffman violated any laws by funding either lawsuit. On the contrary, We're going to use the facts of these cases purely as hypotheticals to discuss the types of legal ethics issues that can arise for a lawyer when someone other than his or her client is financing the litigation. Everything I'm going to discuss here is fully in the realm of potential legal and legal ethics issues, and I do not suggest that any of those issues actually arose in the Hogan versus Gawker or Carroll versus Trump cases, as I have no reason to believe that they did. Our goal is to spot some potential legal and legal ethics issues that could be triggered by these sort of fact patterns so that practicing lawyers can be aware of them should they find themselves in a similar situation. It probably does not surprise you that we have picked the two highest profile ALF lawsuits of all time because of the general level of public interest in those cases. As noted, alternative litigation finance, or ALF, raises four main areas of concern for practicing lawyers. First, illegality. Second, confidentiality. Third, conflicts of interest. And fourth, independent advice. Let's talk first about illegality. At common law, ALF was called champerty, which Black's Law Dictionary defines as an agreement between an officious intermeddler in a lawsuit and a litigant by which the intermeddler helps pursue the litigant's claim as consideration for receiving part of any judgment proceeds. I love that term, officious intermeddler. Is that a synonym for mother-in-law? In the old days, most states outlawed champerty because they didn't want officious intermeddlers stirring up litigation for no good reason. In recent years, most states have moved away from interpreting their common law to prohibit ALF on grounds that it is champertous. This includes California, Florida, and New York, where at least some form of champerty is allowed, although as we shall see in a moment, there is a fair question whether Peter Thiel's unique form of ALF might have been champertous under Florida law. Reid Hoffman's support for Miss Carroll's lawsuit occurred in New York, so champerty would not have been an issue in that case. An interesting point here, Peter Thiel actually went to law school and worked for a very brief period as a lawyer at Sullivan and Cromwell in New York City. But as far as I can tell, he never took the bar or became a member of the bar in New York or in any other state. Had he decided to take the bar and become a California bar member, his support for Hulk Hogan's lawsuit would have been expressly prohibited by California Business and Professions Code Section 6129. New York does not have an analogous statute, so it would be an open question whether Mr. Thiel could have found himself in trouble if he had been a New York lawyer who was funding Mr. Hogan's case against Gawker, as opposed to a non-lawyer. Aside from champerty, an ALF arrangement also could be illegal if it is usurious. Usury laws typically prohibit making a loan that requires payment of interest on that loan greater than the maximum rate permitted by law, coupled with a corrupt intent to take more than the legal rate of interest. The legal rate varies by state, but using Florida as an example, civil usury involves loans of up to $500,000 and an interest rate of greater than 18% and less than 25%, and criminal usury involves any loan amount and an interest rate of more than 25% but less than 45%. Isn't it odd that the definition of criminal usury in Florida has a cap of 45%? Maybe once you're charging someone more than 45% interest, you're committing unarmed robbery and not simple usury. Not all ALF involves the payment of interest. Indeed, many ALF arrangements provide for the financing party only to be paid in the event the plaintiff recovers damages in the case, whereas others require the plaintiff to make interest payments on the amounts advanced while the case is pending, like a typical bank loan. So whether usury is a potential issue for you depends on what kind of ALF arrangement is being contemplated. Since Hulk Hogan is a Florida resident and his case against Gawker was prosecuted in the federal and state courts in Florida, let's take a closer look at how Florida's courts have decided cases involving allegations of champerty, which is governed solely by the common law in Florida, and usury, which is governed by statute. That said, since the contract between Thiel and Hogan could have chosen any state's law to govern it, it's possible that California or New York law applied to it, and as noted above, both of those states tend to permit ALF in most situations. I suppose it's also possible that you could have an interesting choice of law issue. Let's say Hogan refused to repay Thiel the latter's share of his recovery, and Thiel sued in Florida where Hogan lives for breach of contract and to collect the amount Hogan promised to pay. If Hogan raised champerty as a defense, and because the underlying lawsuit was litigated in the federal and state courts, it's possible a Florida court might apply Florida law to that dispute, notwithstanding a different choice of law provision in that contract, on the theory that champerty is about protecting litigants in the courts of Florida and similar to voiding a contract on public policy grounds, which would be governed by Florida law. So again, if you're faced with an ALF issue, I think you need to tread very carefully, including considering all of the states that could be implicated by the arrangement and the underlying dispute and researching the relevant law in that area. On the assumption that Florida law may have applied to the ALF arrangement between Hogan and Teal, a key case interpreting Florida's champerty and usury laws in the context of ALF is the 1996 Florida State Court of Appeals decision, Kraft versus Mason. In that case, Julian Kraft was a plaintiff in a federal antitrust lawsuit against various defendants. When Kraft ran out of money to fund his lawsuit, he approached a third party named Gross to provide that funding in the form of an interest-bearing loan of $100,000, plus a percentage of any amount Kraft might recover as a judgment, starting at 20% of the first $1 million recovered, moving to 6% of the next $4 million recovered, and then to 3% of any recovery in excess of $5 million. Kraft would be obligated to pay the first $100,000 of any recovery over to Gross, which Gross would treat as a repayment of the loan principal. Finally, Kraft would personally guarantee the loan, i.e. it was a recourse loan, and thus Kraft would be required to pay it back even if he did not prevail in the lawsuit. Although Kraft and Gross fully negotiated an ALF arrangement on these terms, Gross ultimately declined to provide the funding to Kraft. So, Kraft did what any desperate person in the same circumstances would do. He asked his sister, Zelda Mason, to loan him the money. Kraft offered Mason the same exact terms he had negotiated with Gross, maybe because she was unsophisticated, or maybe because she was family, or maybe because he just thought that was the right thing to do. If you think it's a bad idea to loan money to your brother, you would be right, because after Kraft won a massive settlement in his antitrust case of $5 million, he refused to pay his sister anything, claiming he was entitled to offset it against amounts he claimed Mason owed him in an unrelated family matter. Kraft also had stopped making interest payments on the loan 5 years earlier, again claiming offset against the other dispute. The court record does not reveal what the unrelated family matter was, but it must have been a doozy since Mason was owed a total of $400,000 based on the terms of the ALF contract Kraft signed with her. When Mason sued Kraft to recover on the ALF agreement, Kraft defended on grounds of champerty and usury. After a non-jury trial, the trial court found for Mason and Kraft appealed. The appellate court affirmed, rejecting Kraft's claims of champerty and usury. The court probably also found Kraft to be a pretty slimy guy who, in a time of desperate need, borrowed money from his sister, dictated the loan terms to her, then stopped paying interest on the loan for years, and when he recovered $5 million, refused to pay his sister her share, citing an unrelated family matter in which he purported to be aggrieved. I think most courts have a heel detector, and this court was no different in using it as a prism through which to view Kraft's claims. In rejecting Kraft's champerty argument, the court actually applied the common law officious intermeddler standard I mentioned earlier, noting that Webster's dictionary defines officious as offering unnecessary and unwanted advice or services, meddlesome, especially in a high-handed or overbearing way. This strikes me as pretty funny that officious intermeddler is still the legal standard for champerty in Florida. The court held that Mason was not an officious intermeddler, reasoning that Mason clearly did not act in an officious manner. She was not intermeddling in a lawsuit. She did not instigate the litigation. Her assistant was sought out by Kraft when he needed money to continue his lawsuit. She did not bargain for the terms under which she made the loan. They too were prepared by Kraft. Nor did she concern herself with the antitrust litigation or impose her views upon the attorneys or the litigants once she provided the loan. So, applying this standard, Mason was held not to be an officious intermeddler. But what result for Peter Teal? While it is unclear whether Teal had anything to do with instigating Hogan's lawsuit against Gawker, or whether he came in after the lawsuit was filed, we now know that he funded at least 2 other lawsuits against Gawker, with the intent of punishing Gawker for its coverage of him and other targets. Remember that Teal has admitted to hiring a team of lawyers to find and help victims of Gawker's coverage to file lawsuits against Gawker, and he funded Hogan's lawsuit alone to the tune of $10 million. I think you could make a strong case that Teal is a poster boy for officious intermeddling in a manner that could be deemed champertus under Florida law. How about that same standard if it had applied to Reid Hoffman's support of Miss Carroll's lawsuit? To be clear, it probably would not have applied because New York generally allows ALF arrangements, and that is where Miss Carroll's lawsuit that Mr. Hoffman indirectly funded was brought. But let's say for the sake of argument that we were judging Mr. Hoffman's ALF activities by the Florida standard. Would he likely to be seen as have violated it? I don't think so for at least 3 reasons. First, unlike Mr. Teal, Mr. Hoffman had not set out to fund lawsuits exclusively against Mr. Trump, even though Mr. Hoffman clearly is a vehement Trump opponent. As far as we can tell, Miss Carroll's lawsuit is the only lawsuit against Mr. Trump that Mr. Hoffman funded. Second, Mr. Hoffman provided funds to an organization, American Future Republic, that in turn chose to provide the funds to Miss Carroll's lawsuit. While Mr. Hoffman is the primary supporter of American Future Republic, he's not the only contributor, and it does not appear that Mr. Hoffman made the decision to fund Ms. Carroll's lawsuit, but rather that others at American Future Republic made that call. Now, clearly the folks at American Future Republic knew Mr. Hoffman's politics and the sort of causes he favored, but that's very different from someone like Mr. Thiel, who went after Gawker specifically and repeatedly until the Hulk Hogan case succeeded in taking down that site. Third, it also appears that American Future Republic did not step in to provide any funding for Ms. Carroll's lawsuit against Mr. Trump until sometime after it was filed. This is similar to Mr. Thiel's support of Hulk Hogan's case. He only came in to help after Hogan had suffered setbacks in federal court, but different from Mr. Thiel's support of the other cases against Gawker, where it appeared Mr. Thiel provided funding from the outset. The point is that Mr. Thiel likely would be held to be an officious intermeddler because he was responsible for targeting and instigating lawsuits against Gawker specifically, versus Mr. Hoffman, who only signed on to an existing lawsuit against Mr. Trump and does not appear to have been involved, at least directly, in the decision to provide that funding to Ms. Carroll. In any case, this is the sort of analysis one would go through in deciding whether ALF's support for a lawsuit is champurtious under a standard like the one that applies in Florida. The other thing we need to examine under the Kraft versus Mason test are the terms of Mr. Thiel's ALF arrangement with Hulk Hogan. Their agreement hasn't been made public, so we have no idea what terms it contained, but I think it's safe to make a couple of assumptions, at least for purposes of our hypothetical fact pattern. First, with Hogan on the verge of bankruptcy and Thiel a billionaire, I think it's fair to assume that Thiel dictated the terms of the deal with Hogan and not the other way around. Now, since Thiel wasn't doing this as an investment, but rather out of spite, he might have given Hogan a very fair deal, maybe even a sweetheart deal. But whatever the deal was, I doubt Hogan dictated its terms to Thiel. This also distinguishes this case from Kraft, where Kraft as the litigant dictated the terms to Mason as the financier. To the extent the court relied on the fact that Mason wasn't setting the ALF terms for Kraft as a basis for finding their arrangement not champurtious, Thiel is unlikely to be able to make the same claim. Second, I think it's fair to assume that Thiel was concerned with the outcome of Hogan's case against Gawker and that he exercised at least some influence over how Hogan's case against Gawker was prosecuted. Again, we have no idea what the contract between Thiel and Hogan provided, in general or with regard to Thiel's ability to direct the litigation in particular, but common sense tells us that a billionaire financier who is funding multiple cases against Gawker is going to have some say in the manner in which those cases are litigated. Clearly, Thiel was very concerned with the outcome of the case, arguably even more so because of his motive to punish Gawker than having a pure financial interest in a recovery. And by virtue of contributing $10 million to the cause, he must have had the ability to impose his views to some degree on Hogan and Hogan's attorneys. This is the polar opposite of Mason, who was unconcerned with the outcome of her brother's case and played no role in it whatsoever. Based on the assumptions we are making about the ALF arrangement between Thiel and Hogan, a Florida court might well conclude that it was champurtious, applying precedents like Kraft versus Mason. We likewise don't have any information about the ALF agreement that American Future Republic had with Miss Carroll, and indeed, from the record we do have, it appears that the agreement actually was between American Future Republic and Miss Carroll's lawyers and not Miss Carroll herself, given she denied having any knowledge of anyone else paying her legal fees. I do think we can assume that American Future Republic didn't control the litigation because they fund many lawsuits, and it appears that this one is the only one against Mr. Trump that they funded. It seems likely that they were supporting the cause of women pursuing sexual assault claims in general, and perhaps women pursuing claims against Mr. Trump in particular, versus pursuing a vendetta against Mr. Trump where they would feel the need to direct each move in that campaign. I certainly could be mistaken about this, but on the facts that we have, it doesn't seem that Mr. Hoffman's support of Miss Carroll's lawsuit would raise the same concerns of champerty as does Mr. Thiel's support of Hulk Hogan's lawsuit against Gawker, for all the reasons I've discussed so far. Going back to the Kraft versus Mason case, what about Kraft's claim of usury? The appellate court rejected that too, finding a lack of corrupt intent. The court said, quote, "Here Mason was an unsophisticated lender. She did not know at the outset the total amount she would receive. The evidence is uncontroverted that it was Kraft who dictated the terms of the loan, not Mason. The loan was to be paid back after the disposition of the lawsuit. Accordingly, no one could have known at the loan's inception the total amount Mason would be receiving in consideration for making the loan. Clearly, the record does not demonstrate the necessary corrupt purpose in the lender's mind to get more than the legal rate of interest." End quote. This is not a cause of an overreaching lender taking advantage of a desperate borrower to impose or undo harsh terms. The court also rejected the usury claim based upon the fact that the amount Mason would receive was contingent on the outcome of the lawsuit, reasoning as follows, quote, "Yet another reason the loan was not usurious is that the money to be paid Mason could be characterized as a bonus to be received for participating in an uncertain transaction. A loan agreement is not usurious when payment depends upon a contingency. Here, when the loan was given, any talk of recovery was pure speculation. Quite possibly there would be no successful recovery from the antitrust litigation, and Mason might have collected nothing beyond the payback of the loan. This contingent nature of any interest to Mason makes the agreement non-usurious. There was no claim that the actual interest Kraft was required to pay Mason was above the legal rate. It was only when you added in the contingent recovery that a claim of usury could be made." Does the court's usury finding have any application to Peter Thiel's alpha arrangement with Hulk Hogan? Probably not, because given Thiel's wealth and Hogan's shaky finances at the time, it seems highly unlikely that Thiel required Hogan to pay any interest on the $10 million he loaned him, at least not in advance of any recovery. I also think it's safe to assume that Thiel's alpha arrangement with Hogan was non-recourse, i.e., Hogan would not be required to pay it back unless he recovered against Gawker, because Thiel doesn't need the money and Hogan couldn't have paid it back anyway. Finally, if the alpha arrangement in fact was non-recourse, that made it contingent on the outcome of the case, which according to the court's reasoning in Kraft makes it non-usurious per se. We likewise don't know anything about the arrangement between American Future Republic and Miss Carroll's lawyers, but I think it's safe to assume the same things that we did about Mr. Thiel's agreement with Hulk Hogan. It was non-recourse and thus contingent on the outcome of the case, and no interest was due. So I don't think either Mr. Thiel or Mr. Hoffman has to worry about having entered into a usurious alpha arrangement. But in other situations, such as where the plaintiff is required to pay interest to the financier, where the loan is guaranteed by the plaintiff, and where some portion of the repayment is not contingent on the outcome of the case, you might well have a usury issue. It's best to think through all of these possibilities if you are asked to advise a client in connection with a potential alpha arrangement. Returning now to the second area of concern for a lawyer whose client is involved in an alpha arrangement is the duty to maintain client confidences. ABA Model Rule 1.6a provides that, quote, "A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B," end quote, which allows disclosure without client consent in certain limited cases, such as disclosure in order to prevent death or substantially bodily harm, or the crime fraud exception we mentioned a moment ago. Most states' ethics rules are similar in this respect to Model Rule 1.6. In alpha arrangements, the potential disclosure of client confidences comes up first at the outset when a financier is deciding whether to fund a particular lawsuit, and second, throughout the course of the lawsuit, when a financier is being provided with updates and potentially taking part in the decision whether to settle the matter. In both cases, a lawyer must take great care to ensure that no client confidences are disclosed without the client's informed consent. Indeed, the California State Bar recently issued Formal Ethics Opinion number 2020-204, exploring an attorney's ethical obligations in ALF cases, and one of the areas of concern was an attorney's obligation under Rule 1.6 to maintain client confidences. While the ethics opinion did not find that lawyers who provide information to ALF financiers to evaluate the merits or progress of a case necessarily violate Rule 1.6, focusing instead on the portion of the rule that allows confidential information to be shared with the client's informed consent. Informed consent requires the lawyer to include the risks of sharing such information, such as waiver of the attorney-client privilege, as I will discuss shortly, in the discussion with the client in which such consent is obtained. Thinking first about what information a financier would need about a case at the outset in order to determine whether or not to fund it, while a lawyer certainly could and should provide only non-confidential and non-privileged documents and information to allow the financier to get up to speed on the matter, such as a copy of the contract at issue in the lawsuit, letters exchanged between the parties, etc. But at some level, financiers are going to be looking for more than just the cold factual record, including ideally a lawyer's assessment of the strengths and weaknesses of the client's case in order to make an informed funding decision, particularly if there are large amounts of money at issue in terms of the funds needed to prosecute the case or the potential recovery. That information would be privileged, and disclosure of that information risks waiving the client's privilege. The problem only gets worse if the financier elects to fund the case and, in return, the client gives the financier the right to receive periodic updates or to participate in important decisions affecting the lawsuit, such as whether to settle for the amount the defendant has put on the table or hold out for more. No lawyer can provide those sorts of updates or discuss those sorts of issues with the financier without providing client confidential and almost certainly privileged information. But wait, you just said that such disclosures are allowed by Rule 1.6 as long as the client gives informed consent. True, but what does informed consent look like in these cases, and is the client really consenting in the sense of a knowing and truly voluntary consent to such disclosures? Let's use the facts of the Hulk Hogan case as our hypothetical. Given that it was going to take $10 million to prosecute his case against Gawker, and given that Hogan was near bankruptcy, he only had 3 options. 1, don't challenge Gawker's publication of the sex tape. 2, challenge it but get a law firm to take the case on full contingency. And 3, challenge it and get a financier to pay all or at least most of the cost. Obviously, he chose door number 3, and I assume it was because door number 2 was not available to him, and door number 1 didn't give him any hope of finding a way out of his financial woes. So you have a client whose only real option is an ALF arrangement if he wants to vindicate his rights and have a shot at a large recovery. We don't know if Ms. Carroll's lawyers were in a similar situation, but I doubt it, as they were likely a number of other people and organizations who would have been willing to fund Ms. Carroll's lawsuit against Mr. Trump had Mr. Hoffman's organization not allegedly stepped forward. So, far from having no options, I suspect Ms. Carroll's lawyers had plenty of ALF avenues they could have gone down, and necessarily probably didn't have to provide much, if any, information to potential financiers either at the time the funding was secured or in the form of periodic updates. Obviously, both the Gawker and Trump cases are likely unique in this respect, so in more typical ALF cases, the need to get informed consent from a client prior to any disclosures of confidential information will be present in order to satisfy an attorney's duties under Rule 1.6. An interesting aspect of the notion of informed consent is the challenge of it truly remaining consensual once an ALF relationship is established. Even if a litigant had a choice whether to start an ALF arrangement, more like Ms. Carroll's lawyers than Mr. Hogan, who had little alternative, does he or she continue to have a choice down the line? I would argue that in many cases, once a client makes the decision to start down the ALF path, he or she doesn't have the option to say no to other choices that are part and parcel of bringing in a financier, such as consenting to the disclosure by your lawyer of confidential and privileged information to the financier. Your lawyer can and should advise you of the risks and consequences of a waiver of confidentiality and privilege, but if you have no choice but to consent despite the risks, I don't know how real that consent really is. But maybe if the risk of waiver is low, the failure to obtain truly informed consent in cases involving ALF might not be such a big deal. So, how high is the risk of waiver? The answer is extremely high. In Leader Technologies versus Facebook, Leader was prosecuting a patent infringement case against Facebook and turned to a financier to help it fund the lawsuit. After Leader shared privileged technical documents with the financier, a federal magistrate judge ordered Leader to produce them to Facebook, rejecting Leader's claim that the disclosure was protected by the common interest privilege. Leader argued that the common interest was Leader's interest in having the lawsuit financed, and that the documents were shared only after the financier had provided the funding. The District Court for the District of Delaware was not moved, holding that in order to give sufficient force to a common interest claim of privilege, there must be a demonstration that the disclosures would not have been made but for the sake of securing, advancing, or supplying legal representation. Further, for a communication to be protected, the interests must be identical, not similar, and be legal, not solely commercial. Accordingly, the court held that Leader waived its privilege claim over the documents by sharing them with its financier. Of course, we don't know whether Leader gave its counsel its informed consent to disclosure of these documents, but we certainly know how things turned out for Leader. The problem only gets worse in very large cases where multiple financiers are involved due to the large amounts needed to fund the litigation or out of a desire to spread the risk. In those situations, disclosure of privileged information to a half a dozen financiers is almost certainly going to result in a waiver, given that the interests of these money men are not going to be identical to the client's interests, or that they will have the required legal interest as opposed to solely commercial interest in the case. Now, you can note correctly that the district court in Leader was reviewing the magistrate's discovery rulings on a clearly erroneous standard, and that the magistrate judge himself had found, after surveying the applicable case law, that this is a developing area of the law and commented that his decision was a close call. But at the end of the day, Leader was held to have waived the privilege by disclosing documents to a financier. Nor is Leader the only court to have found a waiver in ALF cases, so this is a very real and very high risk. In an odd twist, the fact that any disclosures in the Hulk Hogan case would have been made only to Peter Thiel probably helps the argument that those disclosures did not constitute a waiver of common interest privilege. As noted, Thiel's interest was not at all commercial, and as someone who was funding and coordinating several lawsuits against Gawker, you could argue that his legal interests as a victim of Gawker were probably as close to Hulk Hogan's as you could get for a financier. I expect in most other cases that required $10 million to fund them, you would have been dealing with multiple financiers and not just a single billionaire. Even in the case of the American Future Republic's funding of Ms. Carroll's lawsuit against Mr. Trump, you still likely only had one entity who would be receiving any confidential information. And similar to Mr. Thiel, the interests of that organization were very much aligned with Ms. Carroll's interests. This was not a case where the funding entity was simply looking to make a profit, but rather it was politically and ideologically motivated to support Ms. Carroll, such that their interests were also very much aligned. I also think a court might rule differently on whether disclosures to a financier, particularly where, as in the Hulk Hogan case, but for a financier there would have been no lawsuit, can meet the standard that such disclosures would not have been made but for the sake of securing, advancing, or supplying legal representation. Those facts might not be true in Ms. Carroll's case, but I don't think anyone can dispute the but-for causation between Mr. Thiel's decision to fund Mr. Hogan's lawsuit and his ability to continue that lawsuit after the setbacks he suffered in the federal court. You also could distinguish the Hulk Hogan case from a situation where a large company that could afford to fund a litigation elects to enter into an alpha arrangement simply to lay off its risk or to keep those costs off its income statement. In those cases, you might say that the disclosures were not the but-for cause of supplying the representation versus the Hulk Hogan case where they arguably were, given Hogan's apparently lack of other options. That said, in its bankruptcy proceeding, lawyers for Gawker asked the bankruptcy judge to compel Hulk Hogan's lawyers to produce any agreements and communications between themselves and Peter Thiel, presumably arguing that any privilege that they may have attached to those communications has been waived. The case was settled before that motion was decided, so we'll never know how that judge would have ruled on it or what those communications and agreements actually contained. We may yet be able to view those agreements in the Trump case, as I am sure Mr. Trump's lawyers will seek them in aid of their appeal, and it seems unlikely that Mr. Trump will choose to settle that case anytime soon. To sum it up, a lawyer is required by the ethics rules to obtain a client's informed consent prior to disclosure of any confidential or privileged information. Informing a client includes advising him or her of the very real risk that such disclosures of such information to a financier under an alpha arrangement might result in a waiver of privilege and the effects that can have on the lawsuit. Even if the client consents, and query whether that consent is truly voluntary in many of these cases, a lawyer should disclose only the minimum amount of confidential or privileged information that is required in the lawyer's judgment to satisfy the client's obligations to the financier under the alpha arrangement. For further guidance, please consult the California State Bar's Formal Ethics Opinion number 2020-204, the New York City Bar's Formal Ethics Opinion 2011-2 on third-party litigation financing, and the ABA's Informational Report on Alternative Litigation Finance, also from 2011. The next issue that alpha arrangements can raise for lawyers is the likelihood of conflicts of interest. If you take a look at the ABA's informational report, the committee identifies a dizzying array of potential conflicts of interest between a lawyer and the client that alpha arrangements could create depending on their terms. Aside from the prohibition on a lawyer taking an interest in a client's case set out in California Business and Professions Code section 6129 that we discussed earlier, an ABA Model Rule 1.81, which also prohibits a lawyer from taking an interest in a client's case other than a lien for the lawyer's fees and expenses and a contract for a reasonable contingent fee in a civil case, we're going to talk about two potential conflict of interest scenarios. As noted, however, these two scenarios are by no means exhaustive of the potential conflicts alpha might create for you as a lawyer. The first is where a lawyer receives a referral fee from a financier for referring a client to the financier. The second is where, as a result of the client entering into an alpha arrangement, the terms of that arrangement affect the rights that the lawyer and the client have vis-a-vis each other in the proceeds of any recovery. It's not surprising that many clients who enter into alpha arrangements do so as a result of advice they got from their lawyer. It's natural for a client who is trying to figure out how to fund a lawsuit to ask his or her lawyer what options exist, such as a contingent fee arrangement, a bank loan, or an alpha arrangement. Indeed, in the case of Ms. Carroll's lawyers, they obtained the financing directly from Mr. Hoffman's organization, apparently without any participation or even knowledge of the arrangement by their client. On that point, it may be worth noting that Ms. Carroll's lawyers were ethically obligated to inform Ms. Carroll that the funding was being provided and to obtain her informed consent prior to accepting that funding. ABA Model Rule 1.8F prohibits a lawyer from entering into an agreement for or accepting compensation for representing a client from one other than the client unless the client gives informed written consent, the lawyer complies with the lawyer's duty of confidentiality, and the payment arrangement will not interfere with the lawyer's independent professional judgment or with the lawyer-client relationship. In addition to being an ethical requirement, it's obviously a good idea, particularly in cases where the source of that funding can be controversial. 99 times out of 100, the client is going to say fine, so no reason not to inform the client of the funding and get his or her informed consent beforehand. Based on the court filings in the case to date, there seems to be some controversy over whether and when Ms. Carroll's consent that her lawyers could accept the funding was obtained, so we'll see how that plays out in the appeal. It's also natural for lawyers to develop relationships with financiers. If you handle a matter where a financier was involved, you know that person is a potential source of funding for your clients in future matters. In those cases, can a lawyer ethically accept a referral fee from a financier for referring a client to him or her? The answer is, it depends. Under the ABA model rules, while lawyers are prohibited from paying others for referrals of clients, that's Model Rule 7.2b, there is no express prohibition on the lawyer receiving a fee for referring clients to others. However, depending on the size of the referral fee or the overall relationship between the lawyer and the financier, a lawyer might develop a concurrent conflict of interest that could violate Model Rule 1.7a2. That rule requires that, quote, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer, end quote. In this case, the third person is the financier, who is paying the lawyer referral fees and to whom the lawyer may feel beholden if the relationship between the financier and the lawyer is a significant one. Payment of the referral fee also creates a personal interest for the lawyer in those fees that could be at odds with the interests of the client. If, for example, entering into an alpha arrangement with the financier isn't in the client's best interests. If you suppose that the referral fee is significant, let's say $50,000, that's a pretty significant interest for the lawyer, particularly if the lawyer sends a client to the financier once a quarter. Now, we know that concurrent conflicts of interest are waivable by the client. Model Rule 1.7b provides that, quote, notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if, 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client, 2, the representation is not prohibited by law, 3, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal, and 4, each affected client gives informed consent confirmed in writing, end quote. So under the ABA model rule approach, a lawyer could receive a referral fee from a financier if the lawyer believes he or she can provide competent and diligent representation and if the client provides informed consent in writing. The approach in other states is different, however. For example, while New York follows the model rule approach to concurrent conflicts of interest, New York has a separate rule, New York Rule of Professional Conduct 1.8e, that provides as follows, quote, if a lawyer shall not accept compensation for representing a client or anything of value related to the lawyer's representation of the client from one other than the client unless, 1, the client gives informed consent, 2, there is no interference with the lawyer's independent professional judgment or with the client-lawyer relationship, and 3, the client's confidential information is protected as required by Rule 1.6, end quote. This is broader than its model rule analog, ABA Model Rule 1.8f, which just prohibits a lawyer from receiving compensation, but not anything of value related to the lawyer's representation of the client. The New York State Bar, in two formal ethics opinions, number 671 issued in 1994 and number 682 issued in 1996, interpreted the precursor to the current Rule 1.8f to prohibit a lawyer from receiving a referral fee where the amount of the product or service depends on the lawyer's advice, even if the client consents to it. Where the client is entered into an alpha arrangement, the ALF terms the client is offered will depend, at least in part, on the lawyer's assessment of the merits of the underlying case, which implicates the prohibition on the lawyer receiving a referral fee under New York Rule of Professional Conduct 1.8f, as interpreted by the New York State Bar. Accordingly, a New York lawyer is probably barred from accepting a referral fee from a financier in an ALF arrangement, even if the client consents, due to the inherent conflict of interest the referral fee creates, given that the lawyer plays a role in determining the terms that the financier will give the client in the ALF deal. For other states, I recommend you take a look at this issue under your state's ethics rules to determine whether your state follows the ABA model rule approach, where such conflicts are waivable with informed written consent, or the New York approach, where such conflicts cannot be waived. California also follows the ABA approach, where such conflicts can be waived with informed client consent. Take a look at California State Bar's Formal Ethics Opinion number 2020-204 for further guidance. The second potential area where conflicts of interest can arise is where, as a result of the client entering into an ALF arrangement, the terms of that arrangement affect the rights that the lawyer and client have vis-a-vis each other in the proceeds of any recovery. Let's suppose, solely for the purposes of our hypothetical, and I have no reason to believe this was actually the arrangement between Hulk Hogan and his lawyers, that when Hulk Hogan made the decision to sue Gawker, his lawyers agreed to take the case on a traditional, pure contingency fee basis. Under that arrangement, Hogan's lawyers would bear all costs associated with prosecuting Hogan's case, and in the case of success, they would receive 30% or 33% of the recovery or settlement, with the remainder going to Hogan. In the case of failure, the lawyers would receive nothing and Hogan would have no obligation to repay the lawyers for their costs. In that scenario, Hogan's lawyers bear all of the risk and receive roughly a third of any recovery as a reward for taking on that risk. Let's further assume, again, I have no reason to believe this actually happened and solely for purposes of our hypothetical, after Hogan suffered his 2 defeats in federal court, his lawyers came to him and said that they could not afford to continue the case on a pure contingency fee basis because they now expected Gawker to fight even harder and that it would cost approximately $10 million to prosecute the case through a trial, which was more expense than Hogan's lawyers were willing to bear. At that point, Thiel stepped in and offered to fund the litigation and to continue to give Hogan's lawyers some participation in the recovery to incentivize them or as a success fee, and Hogan asked his lawyers to help him negotiate the ALF deal with Thiel. If, as one would expect, Thiel insisted in these negotiations that he be repaid first out of any recovery, you now have a situation where Hogan's lawyers have a pecuniary interest, their interest in any recovery, that is potentially adverse to Hogan's interest in bringing in Thiel as a financier. Now, it's possible Hogan's lawyers chose to move to a straight fee for the services arrangement once Thiel came in to fund the litigation, but I think it likely that they retained at least some participation in the recovery, or at least for their sake I hope that they did, given the $140 million jury verdict and $30 million settlement they ultimately obtained for Hogan. In California, Rule 1.8.1, entitled Business Transactions with a Client and Pecuniary Interests Adverse to a Client, provides that, quote, a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless each of the following requirements has been satisfied. A. The transaction or acquisition and its terms are fair and reasonable to the client, and the terms and the lawyer's role in the transaction or acquisition are fully disclosed and transmitted in writing to the client in a manner that should reasonably have been understood by the client. B. The client either is represented in the transaction or acquisition by an independent lawyer of the client's choice, or the client is advised in writing to seek the advice of an independent lawyer of the client's choice and is given a reasonable opportunity to seek that advice. And C. The client thereafter provides informed written consent to the terms of the transaction or acquisition and to the lawyer's role in it. End quote. The point here is that anytime a lawyer moves away from a traditional contingency fee arrangement, where in most cases the lawyer's interests are fully aligned with the interests of the client, you create the potential for a conflict of interest between the lawyer, the financier, and the client concerning how any recovery is to be divvied up. Thankfully, California Rule 1.8.1, which is modeled on ABA Model Rule 1.8, and similar rules in other states lay out the process for curing this conflict, namely, full and fair disclosure of the terms of the deal to the client, reasonableness of those terms, advising the client of the opportunity to seek independent legal advice, and prior written consent to the deal by the client. I mentioned before the potential issues with obtaining truly informed consent from a client who has no real alternative than to enter into an ALF arrangement and no opportunity to negotiate the terms of that deal, and I would echo those concerns here. Of course, criminal lawyers obtain informed consents from their clients who plead guilty all the time, and those consents are legally valid, even if the client had no real alternative to pleading guilty, so I don't want to overstate the issue or suggest that it is unique to clients in ALF arrangements. My only point is that many clients who enter into ALF deals do so because it is their only means of prosecuting their claims, and then in those kinds of cases, a client may feel that his or her informed consent to things like disclosure of privileged information or waiver of multiple conflicts of interest involving his or her lawyers are not really freely given, even if they are legally binding. The final area of concern we are going to discuss today is a lawyer's obligation to give a client independent advice despite the fact that the lawyer's fees are being paid by the financier and not the client. ABA Model Rule 5.4c provides that, quote, A lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services." End quote. It sounds easier than it actually is to fulfill this obligation in ALF arrangements, where, in addition to simply paying the lawyer's fees, the financier typically has certain rights to direct or control the litigation, particularly in non-recourse ALF deals. For example, a financier might have the right to object to undertaking some discovery that the client or the lawyer wants to pursue because the cost would be significant, or to object to a proposed settlement that does not meet the financier's expectations in terms of the monetary compensation the financier would receive. In those cases, it is the duty of the lawyer to ensure that he or she is serving the client's interests first and is not allowing the financier's interest to compromise the lawyer's single-minded devotion to the client. The lawyer also needs to ensure at the outset, when the client is making the decision to give up some measure of control over the litigation to the financier, that the client understands and truly appreciates what he or she is giving up when entering into this type of ALF arrangement. The California State Bar also expressed great concern about the duty under Rule 2.1 to provide candid advice and to exercise independent professional judgment in ALF cases in Formal Ethics Opinion number 2020-204. The opinion observes that, quote, "Litigation funding, like a third-party payor, introduces a third party with its own interests into the lawyer-client relationship, posing risks to the lawyer's independent professional judgment and the relationship of confidence between the lawyer and client. The duty of loyalty and independent professional judgment require the lawyer to act in the client's interest at all times, and particularly where the client's interests might depart from the funder's. The lawyer's independent professional judgment may also be impaired if the funding arrangement imposes limitations on how the case is litigated." The opinion concludes, "The committee does not reach a general conclusion that any particular degree of control is per se unethical. However, it is clear that where the funder has some degree of control of the litigation, the lawyer has an obligation to advise the client about the impact of such limitations on the lawyer's representation. A lawyer's duties are not dictated by the funding contract, but by the lawyer's ethical duties." End quote. Of course, we don't know whether any of these potential issues came up in the Hulk Hogan case, but you can imagine a couple possible scenarios. Let's say Gawker offered to settle by pulling down the sex tape and the associated commentary, but was unwilling to pay any monetary damages. If Hulk Hogan's primary interest had been in getting the tape and article taken down, and Teal's primary interest was in winning a large monetary award against Gawker to recoup his costs and to put Gawker out of business, that could have created a potential conflict between Hulk Hogan and Teal. Or you could imagine the opposite case, where Teal grew tired of financing the litigation, not likely for Teal, who has more money than God and who was out to get Gawker, but would be an issue for many other financiers as the legal bills keep adding up, and wanted to accept a settlement proposal, whereas Hogan wanted to see the matter through to its conclusion, win, lose, or draw. In either scenario, Hogan's lawyers would have had to manage the conflicting interests of Hogan and Teal very carefully in light of whatever provisions Hogan had accepted in the ALF arrangement and their ethical obligations to Hogan under Model Rules 2.1 and 5.4c. One tactical decision that we know was made in the Hulk Hogan case that raised some eyebrows was the decision not to include a claim of negligent infliction of emotional distress, instead pleading only intentional torts, so that neither Gawker's directors and officers or errors and omissions insurance policy was triggered. This meant that Gawker had no insurance coverage to pay its legal fees and costs to defend the case or to pay any judgment. Some commentators have suggested that this decision reflected Teal's influence. His goal was not to actually collect money from Gawker, but to make the litigation painful for them and ultimately put them out of business. Whereas in many cases, a plaintiff who is purely interested in collecting on a judgment would want the defendant's insurance company on the hook, including potentially to facilitate settlement negotiations. While that is a possible interpretation of why Hulk Hogan's lawyers chose not to plead any insurable claims, it's not the only one, as plaintiffs often make tactical decisions about what to plead based on whether they want an insurance company to be paying defense legal bills and costs or to be seated at the table for settlement discussions, independent of a desire to punish or put the defendant out of business. The Trump lawsuit probably didn't involve the same tactical choices, as I doubt Mr. Trump offered any money to settle the claims, which claims he has vehemently denied. Also, while the case has been pending for a couple of years, the issues are relatively narrow in scope, an allegation of sexual assault and defamation that involved primarily only Mr. Trump and Ms. Carroll. In that way, the Trump litigation is probably an outlier in this regard versus most civil litigations with significant sums of money at issue that involve potentially dozens of depositions, thousands of pages of discovery, multiple rounds of motion practice, and offers to settle that require tactical decisions to be made and where the interests of the client and the financier could diverge. This is certainly the case when insurance companies are involved, as they are in many civil litigations. So we're nearing the end of our presentation. Before we go, you may be wondering what happened to Hulk Hogan after he won his $140 million jury verdict against Gawker that resulted in the $30 million settlement. I assume after paying off Teal and maybe also his lawyers if they were still participating in the case, Hogan must have had several million left over for himself. So everything is hunky-dory for the old Hulkster, right? Not so much. Apart from being theoretically embarrassed by the sex tape because it showed him having sex on camera, the sex tape also caught Hogan expressing disgust with the notion of his daughter being with any black man that included Hogan repeatedly using the N-word. Mr. Hogan apologized for his remarks, but the damage already had been done. First, the WWF terminated its contract with Hogan, stating that they are committed to embracing and celebrating individuals from all backgrounds. Second, Mattel stopped producing Hulk Hogan action figures. And third, Target, Walmart, and other stores pulled Hulk Hogan action figures and other merchandise off their shelves and their online stores. What about Mr. Trump? One day after he was found liable for sexually abusing and defaming Miss Carroll, Mr. Trump, who is once again running for president, appeared at a CNN town hall and blasted the decision in an exchange with anchor Caitlin Collins. "This is a fake story," he said. "She's a whack job." In a letter sent to Judge Kaplan just after town hall, Ms. Carroll's lawyers asked to amend an older, separate lawsuit to make note of Trump's CNN comments, saying the former president's remarks provide further evidence that he has acted maliciously and should be punished with a large punitive damages award. Kaplan still must rule on several legal issues that will determine whether that case can proceed to trial. Mr. Trump is also currently under indictment for felony fraud in another New York case arising from hush money payments that were made to porn star Stormy Daniels. That case is set to go to trial early in 2024. Suffice it to say that neither Mr. Trump nor Mr. Hogan is living his best life at the moment. I hope you enjoyed today's presentation. Thanks for watching.